In the war for our right to keep and bear arms, there are battles that are fought. Some are obvious, some are less obvious. I'm going to bring your attention to a mission-critical battle for our right over whether or not the Supreme Court is going to hear the Bianchi case, now known as the Snope case, involving whether or not states can ban the possession of AR-15 style firearms. We're going to talk about the Snopes case and something mission critical that's occurring right now that probably has flown under your radar screen. But we're going to talk about it and bring it to your attention to make you the smartest person in the room when it comes to our Second Amendment rights. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed: What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Check it out on Amazon. And if you have a copy and have reviewed it, feel free to leave a review on Amazon. Always interested in to see what people say about my work. All right, folks, this is probably not on your radar screen. But when I go to bed and think about the most important battles that are being fought over our right to keep and bear arms right now, the first thing I fall asleep to, or try to fall asleep to, is who's going to win the presidential election, and relatedly, who's going to win the Senate. Cheering for Donald Trump to win the White House and the Republicans to win the Senate with 53 or more senators to allow us to nominate and confirm Second Amendment related judges who are favorable to our Bill of Rights, who are favorable to our constitutional system of our republic, and so on and so on. Shortly thereafter, or I should say, a step below that perhaps, is I want the United States Supreme Court to grant cert finally to the Snope case, which used to be known as the Bianchi case, which is the case that arose out of the state of Maryland, dealing with whether or not a state can ban the possession of semi-automatic rifles such as AR-10s, AR-15s, AK-47s, and so on and so on. This is a very big deal, and to me, the most important case in the Second Amendment community before the U.S. Supreme Court by far. Now, we don't know whether or not the Supreme Court is going to grant cert and hear this case, but there is a battle brewing right now that I want you to pay attention to. Very important. Specifically, as you may recall, a couple months ago, the United States Court of Appeals for the Fourth Circuit out of Maryland and Virginia, one of the worst courts in America for our Second Amendment rights. They're not necessarily as bad as the First or the Ninth Circuit, but they're pretty bad, very bad, when you look at the totality of the judges. Not all the judges, but the totality of the judges in the Fourth Circuit. They're extremely bad and hostile, actively hostile to our Second Amendment rights. Well, they issued a very long decision, as we predicted, against the right to keep and bear arms, saying that it was perfectly fine for Maryland to go ahead and ban the possession of ordinary semi-automatic rifles because they're quote-unquote assault weapons and weapons of war. Totally wrong analysis, just terrible, backward thinking, and so on and so on. Nevertheless, they have the rule of law, they have the power of law there in the Fourth Circuit. Now, within a week or two, I think it was within 15 days or so, the Second Amendment plaintiffs in that case, which was known as Bianchi versus Brown and is now known as Snope versus Brown, sought cert from the United States Supreme Court, asking the Supreme Court to hear the case, grant cert and hear the case and resolve once and for all, which is the obvious answer, that of course semi-automatic rifles are protected arms under the Second Amendment, no different than modern handguns are protected arms under the Second Amendment, as we saw in 2008 with the Heller decision. So what is the battle that's brewing right now that you need to pay attention to? And here's the story. Right now, I should say, after that decision was rendered, within 15 days, the pro-Second Amendment forces filed their request for cert by the U.S. Supreme Court to the U.S. Supreme Court. As soon as that occurred, the state of Maryland, the Attorney General's Office of Maryland, with something around the order of magnitude of a $70 million budget, hear what I just said? $70 million budget by the Maryland Attorney General's Office, asked for a 30-day extension in addition to the time they were already allotted by law, an additional 30 days to submit an opposition to the cert petition, which should be very easy, right? Because all the state of Maryland needs to do is say, hey, U.S. Supreme Court, no need to grant cert. There's no circuit split here. The Fourth Circuit did a great job. There's no constitutional question. Easy peasy, just deny cert. Not that hard. The Fourth Circuit, the Ninth Circuit, there's plenty of other anti-gun judges that have done terrible jobs, and they can just cite to. So it's a very easy opposition for cert that Maryland needs to file. Now, the reason why that's important is that despite the fact they asked for an additional 30 days, guess what's just happened? Maryland has come back, and now they're asking for an additional 30-day extension. And now you're looking at me like, hey, Mark, come on. I know you say we need to learn about the substance of the Second Amendment, meaning the text and the history and the tradition of the Second Amendment, right? And I know you sometimes say you've got to learn about the process and procedure of how a case winds its way womb to tomb through the court system, but why on earth are you wasting my time as I'm driving down I-95 in my truck, for example? Why are you wasting my time on this topic? And the answer is mission critical. This, to me, is going to be a signal as to whether or not the Supreme Court grants this extension of 30 days to the state of Maryland, as to whether or not the U.S. Supreme Court is going to hear the case or has interest in this case this term. The Supreme Court term being October 2024 through June of 2025. Why do I say that? Because this is what the state of Maryland asked for. They wanted the additional 30 days on top of the prior 30 days, on top of the original amount of time they were entitled to, supposedly because they're busy with a lot of other litigations. They said, hey, we're really busy. We don't have time to get to this. We really need more additional time. And specifically, they write, the requested extension is necessary to ensure that the undersigned counsel and others can devote sufficient attention to these proceedings as well as the responses to the two petitions in this court, meaning this case and there's some other cases they're working on. Okay, now, the reason why this is a big deal is if they get that 30-day extension, it's going to push off the time for this case to be what's known as distributed to the Supreme Court, to the justices, for them to review. And if it's pushed off 30 days, it delays not only the distribution date to the justices to consider whether or not to hear the case, it also pushes off the date on which the Supreme Court could potentially what's known as conference the case, which means to vote on whether or not to hear the case this term. So as a result of this, the attorneys for Snope have responded and said, we're willing to give them 12 or 13 more days, but we're not willing to agree to the extension of 30 days because what's clearly going on here is an attempt to delay this case and shove the Snope case from the 2024-2025 Supreme Court term into the following next year, which, as you know, the anti-gunners' entire strategy is to delay. And that's what this is attempting to do. So here's what the Second Amendment lawyers on behalf of Snope write in their letter responding to the Maryland request. The Second Amendment parties write briefly to explain their opposition to the request for an extension of time to file an opposition. Here's what they write. Quote, petitioners write briefly, that's the Second Amendment side, write briefly to explain our opposition to Maryland's request for an extension of time to file an opposition to the pending petition for certiorari in this case. As is apparent from our petition, the Second Amendment plaintiffs or petitioners view this case as of critical importance, and to judge by the significant amicus interest in the case, the Second Amendment petitioners are not alone in that view. He goes on to say, in recognition of the importance of the case and desiring an opportunity to present this issue to the court this term, referring to the 2024-2025 term, we filed the petition for a writ of certiorari just 15 days after the Fourth Circuit issued the decision below. As the deadlines in this case currently stand, and after the respondents already received an initial 30-day extension to which we did not object, this case will be distributed on November 6, 2024, and will be considered by the Supreme Court for the first time at the November 22, 2024 conference. With just 3 conferences remaining before the end of the year, a 30-day extension to Maryland would mean that this court would not consider this case at conference until January 10th, 2025. Thus, if the court is inclined to grant any extension at all to Maryland, it should not delay the case more than 13 days to permit this case to be distributed on November 19th, 2024 for consideration at the December 6th, 2024 conference. So again, to make all this easy to understand, Maryland is trying to delay the Snope case before the Supreme Court another full month to try to push this case off into the next term, 2025-2026, to delay a decision on AR-15 bans until June of 2026. The Second Amendment lawyers are very savvy and are doing what their job is, which is to try to prevent this by saying that although we're willing to engage in professional courtesies, having already agreed as a matter of courtesy to the first 30-day extension, we're willing to agree to a slight additional extension of maybe a couple weeks. But the 30 days is unacceptable because it will just be foot dragging. And there's no excuse because Maryland's Office of the Attorney General has a budget of $70 million. And again, it's not that hard to argue this, right? All the Maryland Attorney General has to do is to cite to anti-gun jurisprudence from the anti-gun judges in the 4th Circuit, the 7th Circuit in Chicago, the 9th Circuit in San Francisco, some of these other courts, and just say, see, it's easy, deny cert. There's no right here. See ball, hit ball. It's not a very hard brief to write. In fact, keep in mind, the Maryland Attorney General's office has already written why assault weapon AR-15s are terrible. They've written multiple briefs over many years. So why do they really need more time? It's absurd. They really don't need this time. This is a strategic decision to delay as far as I can see. And it's going to be very interesting to see what the Supreme Court does and whether they grant this 30-day extension or not. May not seem like a big deal, but to me, it's the equivalent of like the Battle of Iwo Jima, right? Which the Allied forces had to win in World War II to have a shot to actually start bombing Okinawa and ultimately the mainland of Japan. So this is a battle, but it's not a random battle, and it's a battle I'm bringing to your attention because it's a battle we in the Second Amendment community need to win. If the Supreme Court gives them that 30-day extension, to me, I would view that as a very, very bad sign that the Supreme Court does not have an interest in taking up the AR-15 ban case this term and perhaps at any point in the near future. I could be wrong, of course. It's always hard to speculate and predict what the Supreme Court's going to do since you're not in the building. You're not part of what's going on in their big picture thinking. But I'm just telling you that what we really do want is the Supreme Court to deny that 30-day extension to Maryland and only give them another week or two. That is the battle within the war that we should be cheering for. And I wanted to bring this to your attention because, again, to make you the smartest person in the room when it comes to our Second Amendment rights, you need to understand these shenanigans, these maneuverings that occur within a case. Just like to understand how you win a war, you sometimes have to understand the strategic thinking associated with particular battles and the tactical considerations that go into the same. And that's why I wanted to bring you this back and forth going on over the extension time before the United States Supreme Court, because it's mission critical to our rights ultimately. And as I've often said on this channel, the history of the future has yet to be written, but it's being written now involving our rights, so let's see what happens. All right, in the meantime, make sure you follow me on X at 4boxesdiner. Please like and subscribe to this channel. We're trying to hit 200,000 subscribers. It's taken us a while to get there, but we're working hard. And so please subscribe to the channel. And again, we'll see you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.